Hello, ladies and gentlemen. I am Carlos Emanuel, and we're going to continue the topic that was on the last video, the one of the legal sciences. But we're going to introduce new concepts, and we're going to try to explain these concepts very good because are the complement of the last topic. Okay, we're going to start. First, we already saw what is the jurisprudence, the resolutions that are dictated in the same way. Also, we have seen that it's very different application in Canada, UK, Great Britain, England, sorry, USA, Australia, India, because the common law is very different and the jurisprudence is applied in a different way than from France, Germany, and Mexico that have another legal system. But that are the precedents and the technical jurisprudence is how the judge was studying the case and how the way was paid so the judge can give this resolution in the Neo-Romanist code. This is the resolution, the jurisprudence, this is the story, technical jurisprudence. We're going to see the classifications of the technical jurisprudence. The first one is the Roman. In the ancient Rome civilization in the second period, the Republic period, it was applied because it was one of the five formal sources of the law, like the edicts of the magistrates, the plebiscites, and other stuff. But it was the application and the interpretation of the law to a specific cases. These were applied by the jurisconsults. Okay, we have seen the Roman laws earlier. Okay, we're going to continue with the German technical jurisprudence, in which in the BGB, that was the replacement of the Napoleonic Code, in which they have 5 books in the Civil Code, not 3 like the Napoleonic Code. They have a jurisprudence in which they want to integrate the law and the jurisprudence as a formal source of the law, having the creation of the new laws from the law that was written, the written law, and the integration of the law from the jurisprudence. That's the German technical jurisprudence. And the last one is the analytic jurisprudence, in which they want to separate the legality and the morality. We're going to explain that. The legality are the punishments, attitudes, obligations, and rights that are applied by the state in the law or in the legal system. The situation is that it's very different from the morality, in which they want to have good values. We're going to have an example that is very explicit in this case is the Manu Code, an historical source that is applied today in some cases in India, that is a religious thing from the Hinduist religion. The situation is that they have penalties from the corruption of the public churches, in which they can mutilate the people and cut the members of the body. That's the situation. It is legal, but it is not moral. That's the difference between the legality and the morality. That's what the technical jurisprudence in an analytic way is studying. And there are so many cases, like the one of the Sharia, the Quran, between the legality and the morality, in which the people in the Sharia, the man also, has the faculty to have a lot of spouses. The situation is that it's not moral. It's legal, but it's not moral. That is the analytic jurisprudence. We're going to pass to the next topic. The object of the study is the procedure of the law, how it's applied, how is applied coercible by the state. It is applied the regulatory from the executive power. Under legal technique are the techniques of the creation, application, interpretation, and integration of the law. It depends on the country, the process to make a law. The statutory law, like the one the legislative process in Mexico, is very different, you know that. But in the legal technique, it's the story of the procedure. Okay, the story of the procedure. We're going to talk about something that is very good to talk when we're all talking about laws. The legal interpretation and integration. There's a difference between them. Interpretation of the law is when you apply the codified law, the codified body, to a specific case. we're going to suppose that someone robbed a bank. You have an application, a law in which you can seek what you want. The penalty for this case, the regulation. The situation is that maybe the case is not such as the one that is talked about and written in the codified law. So you interpret what it exists and apply it to a specific case. The integration is the contrary of that. What? The integration of the law is where you don't have a codified law that supports that case, and you need to create the jurisprudence. We're going to put an example. In Mexico, the juridic figure of the law is not applied by the law. We're going to explain that. Are the spouses and the husbands that are two or more in a matrimony. That's the difference. Two or more husbands in one single matrimony. You can't apply the Civil Code of Jalisco or Mexico or the Processual Code of Jalisco in a civil way to interpret the law and apply it to these cases. No, because it doesn't function. You need to integrate a new law. You don't have a formal source that supplies this. You need the jurisprudence and the basic and general principles of the law to integrate it to the law, to recognize this institution if they want to. I am not agreeing with this, but that is a case. Interpretation, when you apply the law to specific cases. Integration, when you create the law and it's transformed to the codified law. Okay? That's the difference between the legal interpretation and integration. We're going to talk about the vigency and the retroactivity. The vigency are the laws that are being applied today in a legal system. In the legislative process, they can be on an undetermined time or in a determinate time. That are the vigency laws. But we're going to talk about what is the retroactivity. Are the new laws that can be applied to the past cases, but only when it's in favor to the people, not getting rid of the people. Why? You can't affect the people with the new laws. We're going to suppose that the murder of a children in the United States or in Mexico is on a 30 years penalty and an indemnization in the prison. Okay, a new law starts in which that penalty reduces the years and you only have 10 years. What happens to the cases that happens in the past? You can ask for that retroactivity in favor of the law and apply it and reduce your time in the jail. The situation is that they extend, if they extend, to 70 years this penalty, the irretroactivity doesn't function. Why? Because it is applied in danger and not doing in favor of the people. So only in favor of the people the retroactivity is applied, not in the contrary way. Okay, that's the difference. Okay, and the last one are the laws conflict, are where two or more legal systems or states are applied in a single case. We're going to suppose that Frank is Australian and he marries a Russian woman and they have their wedding on England. The matrimony is on England. They have a boy on Morocco and they divorce in another country, Albania. They don't have the same legal system because who are going to apply the laws? The countries of the fathers that are not the same, and one is common law and one is civil law code, the Napoleonic applied in Russia, that is like an historical source from the new legal system of Russia, that is civil law. The situation of Morocco, in which the boy was born, that have a mixed legal system in the civil law or in the Muslim law, the Sharia, in the familiar area. That's the problem. But they get married in England, but they divorce in Albania. That's the law conflict. So we already see this topic. Thank you. Thanks God for this. God bless you. Have a nice day. Thank you for your attention.